Hi, this is Paul Friedman. We wanted to discuss depositions and the taking of depositions and what would be the best course for you. We want to make sure that depositions are as least anxious as possible and that you get the most out of a deposition in helps of your case. So first of all, what is a deposition? A deposition is a sworn statement taken under oath, the same as if you were at trial. The difference is that a judge is not going to be present during the taking of your deposition. Now, depositions can either be in person or they can be via video conferencing, such as Zoom. If it's in person, the attorney that is taking the deposition will be sitting across from you, and one of your attorneys will be sitting directly next to you. So don't worry, you're not going into this alone. There will also be a court reporter there that will be taking down everything verbatim, the same way as if you were in a trial. They can actually read back questions, so it's important that you verbalize answer, either a yes, no, or an explanation for the question. So now you know what a deposition is. Again, it's a sworn statement taken under oath. What's the purpose of depositions? The purpose of depositions is for a few different reasons. The first is that the adverse party wants to see how well you will testify. So it's important that you get plenty of rest the night before your deposition and that you feel as comfortable as possible. The second reason is that they want to utilize something that you say in your deposition against you should the case go to trial. We prepare every case as if it's going to go to trial, knowing that about 20% of our litigation cases actually end up in trial and 80% do not. But our instructions on depositions are the same regardless. We want to make sure that should your case go to trial, that you are completely prepared for it. So the first rule that you need to be aware of is be honest, be truthful. Number one, we never want you to lie. If you lie during a deposition, it is going to come back and it may cost you the value of your case. Make sure that you are 100% honest during the deposition. The second thing that we want you to remember is to only answer the questions asked. If you provide additional information for the adverse attorney, that is most likely going to be used against you at trial. Answer only the questions asked. So now we have two rules. First is to be totally honest. The second is to answer only the questions asked. This is not your opportunity to tell your story. You have to rely on the fact that your attorney, if need be, will ask you questions after the deposition, after the cross-examination, so that there is a complete record. You need to trust your attorney and leave it totally up to your attorney to ask you those questions. The third rule is we do not want you to guess. If you are not 100% certain of the answer, then you need to say, I'm not 100% certain of the answer. The times that are most problematic for clients are time and distance. Unless you're sitting there looking at your watch right before an accident, you probably are not aware of the exact times that occur. Unless you're out there with a tape measure, you're probably not aware of the exact distances. So if you're not sure of the exact time or the exact distance, then say, I'm not certain of the exact time or the exact distance. Those are things that we don't want you to guess about. If you can give estimations, if you can fairly say it was less than 15 seconds or it was more than 5 seconds, and you say that that's an estimate, that's fine. There is a difference between a guess and an estimate. Let me give you an example. Unless you're a baseball fan, you wouldn't know who won the 1922 World Series. So if you gave an answer, that would be a guess. But if I were to say, how long has this video been going on? Without looking at the clock, you could say approximately 3 to 4 minutes, and that would be your best estimate. Estimates are based upon your personal observations. And as long as you preface it by saying my best estimate would be, that would be fine. But again, we don't want you to guess. So what are the three rules for depositions? One, be completely honest. Two, do not give more information than is asked. And three, make sure that you do not guess in a deposition. Now, the attorney on the other side will utilize things that you say during your deposition if those are inconsistent at the time of trial. So it's important that you give the best testimony that you can. If this is a verbal deposition or a video conference deposition but not being recorded, make sure that you listen to the question, that you allow the attorney to get an objection in if they need to, and I'm going to discuss objections, and that you give an answer only to the question that is asked without guessing. So what objections may you hear from our office? One objection is form. It means that there's something about the question the attorney doesn't think should come in at the time of trial. They're making a record for the judge, and the judge will rule later on before trial whether that question can come in or not. Don't worry about the reason that the attorney is objecting to form. If you feel comfortable answering the question and you're not guessing, go ahead and give a response. The second objection would be foundation. That means that in the attorney's mind, you're probably not the right one to answer the question. But again, if you feel comfortable giving an answer, go ahead and give an answer. So the two objections that you're likely to hear are form and foundation. You may also hear privilege instructions. Privilege is an attorney-client privilege. In other words, what you discuss with either your attorney or our office is privileged information. So if they ask you, what did you and your attorney discuss? Then an objection from the attorney is going to be attorney-client privilege and instruct you not to answer. If they ask how you got to a doctor and you got a list of doctors from our office, you can say, I received a list of questions, a list of doctors. And if they ask where you received it from, you can say the law office, and that's as far as you're going to go with regard to that. Now, if they ask you questions like, did you meet with your attorney before the deposition? Then you can say yes. If they ask how long it went on for, you can give them a response. If they ask when it occurred, you can answer that. What they're not entitled to know is what we discussed during our pre-deposition conference. Now, this is just the first step in a deposition. You're going to be meeting with your attorney either by video conference, telephone, or in person to discuss your actual deposition. Before your deposition, we do not want you to review any material. So during your deposition preparation period where you're talking with your attorney, you can ask if you should review any material. If the attorney feels that it would be useful for you to review material, then your attorney will tell you to do so. Most likely, the attorney will not have you review any material for your deposition. If you do review material for your deposition, it is discoverable by the other side. So, unless your attorney tells you specifically to look at documents, please refrain from doing so. If this is a video deposition, we ask that you look directly into the camera. Even if the attorney is to your side asking you the questions, please look into the camera so that it would be just as if you were talking to the jury directly at the time of trial. So again, we want you to remember three things in preparation for your deposition. One is to be 100% honest. The second is to answer only the questions asked. And the third is that we do not want you to guess. We've discussed the objections that may be made at the deposition. If you want to know how long the deposition is likely to go for, the best conversation is to have with your attorney during your deposition preparation. So if we can answer any questions between now and then, make sure that you give us a call. Otherwise, we look forward to seeing you at the pre-deposition meeting and at the deposition. And we thank you for allowing us to be your attorney.